Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos, we are talking about obtaining citizenship, and we have done a few on Section 322. The question happens sometimes. What happens if it's denied? Do you just give up and go through a normal naturalization route, or just not become a U.S. citizen? Well, you have to understand that a lot of times some officers will make the incorrect decision. Sometimes you get new officers that don't quite understand all the ins and outs of Section 322. And so that's why they have the route that you can appeal. Now, if it is denied, you can appeal to the AAO, which is the Administrative Appellate Office, and you do need to do this, of course, before you would ever go into federal court, to show that you have exhausted all your administrative remedies. The hope, of course, is that in the first place the officer doesn't deny it because everything's properly submitted and properly shown that you qualify under this section and that you should become a U.S. citizen. But if that doesn't happen, then yes, go ahead and do a appeal to the AAO, and have everything prepared in such a manner that it shows clearly that the officer did not follow the necessary regulations and provisions under Section 322, what was incorrectly issued as the decision, and why it should be overturned. Now, realizing that although the child must be under 18 when the certificate is issued, the government may equitably stop this particular provision if the delay was due to USCIS or the immigration. So of course this is going to be hard to prove, naturally, but if you can show that it was undue delay by immigration, then even though the child's over 18, they still will be able to get their certificate of citizenship. Now, in the particular case of having to appeal, an example might be, let's say every element is met just perfectly, okay? But let's say that the child, or let's say child's 17 and has a juvenile record, and the officer denies this particular case because of the juvenile record, saying that the child doesn't have good moral character. Well, in Section 322, that's not an element. You don't have to have good moral character in order to qualify under this. It doesn't matter if you committed 22 crimes. As long as you meet the necessary requirements, it should be approved. So that would be an example where you would appeal it because the incorrect law was applied by the officer. Okay, more on the coming videos.